I just wanted to give a quick update about what happened today. 3 of the defendant police officers in the Creepy Cop search case had their video depositions scheduled to take place today. So I arrived there ready to conduct those depositions. Out of the 3 officers who were scheduled, 1 did not show up, I was told, on the advice of a criminal defense attorney. The other 2 officers did show up, and they did answer questions. However, I think we discovered why they really did not want this to happen, and that's because instead of just answering the questions after being placed under oath, they pled the Fifth Amendment. They pled the Fifth Amendment over and over and over again. One of the officers, even when asked, "When did you first become a police officer?" refused to answer that question and instead pled the Fifth Amendment. So what is the difference between doing that in a criminal case and a civil case? Well, in a criminal case, a defendant in a criminal case has the right to invoke the Fifth Amendment, the right to remain silent, and that can't be used against him at trial. The prosecutor can't go in front of the jury and say, well, the defendant refused to answer questions, or he invoked his Fifth Amendment rights, or he's remaining silent, and therefore that must mean he's guilty. Not allowed to do that in a criminal case. But guess what? You can do that in a civil case. In fact, the law is, if you plead the Fifth in a civil case, then an adverse inference may be drawn against you. In other words, the jury or the court may get to assume that your answer to the question that you refused to answer is going to incriminate you. Therefore, what did I do? I continued to ask questions even though they weren't being answered. And so over and over again, I asked all the questions. None of those questions basically were answered, not just regarding this event that was involved in this lawsuit, but also other allegations of misconduct. That's basically what happened, and it really was an interesting experience. The emotions in the room, I think, really, I'm very glad that there was a video camera capturing it, because I don't think words can convey what it was like and really what I was witnessing in real time. But perhaps at some point, that's something that the public will get to see. As I discussed in the last video, on Friday they filed a motion trying to restrict me from ever using these video depositions as YouTube content. And they cited safety concerns and all that. And so I asked a lot of questions about that today. But I think we see what the real reason is here, don't we? And that's because they don't want the public to see that once placed under oath, these tough guys that you saw in the video and that show up to people's houses at these knock and talks, these tough guys, when actually put in a room with me and a court reporter and a video camera and they're placed under oath, they apparently aren't so tough anymore and they're too afraid to answer questions. Instead, they just plead the Fifth Amendment over and over and over again, obviously not wanting the public to know what their answers would be. And the law is going to be, I think, that the court, the jury, and even the public can draw adverse inferences on what their answers would have been, and that those answers would be incriminating towards them. So I really now look forward to conducting some more depositions in this case. I look forward to the trial in this matter. There's going to be a lot of adverse inferences involved, I think. So if you want to continue to follow along, please make sure to subscribe both here and at the blog at thecivilrightslawyer.com. And God willing, I will be able to continue to provide updates, to continue to expose misconduct that has been concealed for a long time using the power of the state.